SJC-13045, Commonwealth versus Michael A. Noguera.
Attorney Sultan.
Good morning, Madam Chief Justice, and may it please the Court. Defendant Michael Noguera shot and killed Daniel Smith in a wooded area of Easton on November 8th, 2016. Noguera and Smith were friends and traveling companions, but it was an abusive relationship. Smith took away Noguera's cell phone, he threw away his medication, he pointed a gun at him, and in the days just preceding the killing, he repeatedly threatened Noguera and Noguera's family. Noguera went to trial in 2020 after the trial had been continued due to concerns about Noguera's mental health and the filing of a court-ordered 15A report which chronicled Noguera's long history of mental illness and mental health treatment. Noguera testified in his own defense at trial. He described his history of mental illness and Smith's abuse. He testified that he killed Smith in self-defense. On cross-examination of Noguera, the prosecutor challenged the defendant's claim of mental illness based upon the absence of any records corroborating that claim.
Mrs. Sultan, can we jump right into that, because this does seem a little bit different than Solankas and the appeals court case that you cited. Certainly different than Commonwealth versus Gardner when there was cross-examination on manslaughter. The first difference is that your client took the witness stand. And the second difference is in the Solankas and the appeals court case, the name is escaping me, they were the victim's records, not the defendant's own records. So if you take those trilogy of cases, how do you reconcile those with the circumstances here where your client made a decision to take the stand, schizoaffective disorder was a key to the case, and yet he didn't have those records? How does that implicate improper cross-examination?
Well, I agree with Your Honor that under this court's cases and Ivey and appeals court cases, it's at least it's a much closer question, and because he did take the stand, and I think it is somewhat analogous to situations where somebody decides to talk to the police and answer some questions and not others. Frankly, that is not one of my two principal arguments. I'm not waiving that argument, but I recognize, especially where it wasn't objected to at trial, where cross-examination obviously is within the discretion of the trial judge. I'm not resting principally on that argument. But I think that it does jibe with what are the two principal arguments, which are related, which we raise on this consolidated appeal, which are, first, that trial counsel was ineffective and deprived Noguera of a substantial defense by not obtaining and using at least 4 specific sets of records that would have blunted that argument.
Let me ask you on that score, Mr. Sultan, as far as the judge's findings on the motion for new trial go in the record, what you didn't address in your brief was the examination by Dr. Salah, and then the investigation that Mr. Camera did with Salah and Brown, which used some of the records, not all of them. Could you please address, or take the opportunity to address how those pretrial examinations or investigations by Attorney Camera would not be ineffective?
I don't think that those are particularly germane, Your Honor, because defense counsel didn't call either of those experts at trial.
But we have lots of case law that says when you, as obviously a very experienced defense attorney, the obligation is to look at the mental health when raised and do an investigation of it. And we don't have an obligation to go down rabbit holes or raise spurious defenses. So at bottom, Camera called in 2 experts, had them examined, and then said, we're not going there. So how does that jive with ineffective assistance?
Well, Your Honor, because the obligation is to make a reasonable investigation. And a reasonable investigation, and this, I mean, to me, the case that's most directly on point is Alvarez, where, I mean, the defense in that case put on an expert, but the defense didn't obtain the full set of records that would have corroborated the defense, the NGI defense. And so what this court said is there was no strategic reason not to get those records. There was no strategic reason not to review those records. Those records would have assisted the presentation of the defense. So here, I mean, frankly, if those experts opined without even seeing those records, I mean, what kind of an opinion is that?
Well,
it's a standard part of what a lawyer's job is to get the
Challenge that
records.
point, though?
I'm sorry, Your Honor?
Can we just challenge that point for a minute?
Sure.
That the expert didn't review those records. I think you might be referring to Dr. Brown, because there is a suggestion that the Suffolk jail records were reviewed. There's a suggestion that the Social Security Administration records were part of the Hackensack University hospital records, and that those records were reviewed. Now, I don't know. I haven't taken the big dive in yet to know, but that's the suggestion that, no, wait a minute, you said, and there was no review of those records. There's a suggestion from the Commonwealth that indeed a good enough amount of those records were reviewed to say, stop, don't go there, because this is going to step on your long-standing mental health schizo disorder defense.
Well, let me address that, Your Honor. Well, first of all, as this court has said, going back decades, doing the investigation, including getting records, does not in any way create a discovery obligation. It doesn't require you to use those records. It's just part of the pretrial investigation. So let's talk about the 4 sets of records. So first, the military records, where the defendant made a serious suicide attempt, and the records also document earlier suicide attempts and a medical discharge. Trial counsel concedes he never got those records. There was no request in the file, so the experts couldn't have them either. He never got them. The Social Security disability records. The man had been on Social Security disability. The disability dated back to from 1989 to 2014 when he didn't submit updated records, so they took him off. So that's 25 years. He never obtained those records. The Commonwealth suggests, well, some of those records might have been someplace else, but the complete set of records, which documented a long disability, including a mental health disability, the defense counsel never got those records. He had conceded he never did it. And so the experts never could have seen those records. So the third set, the Hackensack Medical Center, University Medical Center, emergency psychiatric hospitalization in 2010, which directly corroborates Noguera's testimony at trial. He was asked by the prosecutor, when were you last hospitalized? And he said 6 to 8 years ago. And that was 6 or 8 years before the killing. Well, 2010 was 6 years before the killing. I mean, that's exactly fits his testimony. Those records were never obtained. There's no suggestion that those Hackensack records were part of any other record. Now, during the evidentiary hearing, in his affidavit, trial counsel says, I never sought or obtained those records. In his testimony, he said, well, I might have gotten those records. He had no recollection of ever reviewing them, so there's no reason to believe that
Just be clear, Mr. Sultan, by those records, you're referring to Hackensack.
The Hackensack records, Your Honor. And then the fourth set are the jail records. So, upon his entry into the Suffolk County Jail in the summer of 2018, Noguera was evaluated. If you look at page 515 of the impounded appendix, the impression is schizoaffective. He's put on psychiatric meds. I mean, those records were important. That yes, they were just like in Alvarez. In Alvarez, the complete set were summonsed in at the prosecution's instigation, but the defense never looked at them. There's no evidence that Dr. Brown ever looked at those records. His 15A report came out like 2 days after those records were summoned in. There's nothing in his report that refers to those records. There's no reason to believe he ever bothered to go to the clerk's office and looked at the records. And trial counsel admitted he never looked at the records. He didn't look at them. He didn't have them. He was not in a position to offer them at trial. That's negligence, Your Honor. I understand that lawyers can't do everything. They can't go down every rabbit hole. This wasn't a rabbit hole. Noguera sent his lawyer a specific list of pages of all of the places he had been hospitalized, all the medication he had been on. The material was there. It's hard to do. I respect that.
Records seem important. I know the DA is going to make the point that it's obviously after the homicide. I appreciate they're going to make that point, but the records are important because that's where you have a potential diagnosis, a schizodiagnosis. So they are important records. Is there any resolution in the factual findings or anything that we can look to as to whether or not Dr. Brown did review those records?
Well, there isn't, Your Honor, because the trial counsel didn't keep a record of what he had sent to Dr. Brown. He didn't keep a copy of what he sent to Dr. Brown. And Dr. Brown reported during my investigation that he had destroyed the records when he moved offices. So there's really no way of knowing what he looked at. What we do know is that there's no reason to believe that counsel had them at trial.
What does the record reveal, Mr. Sultan, about the records reviewed, if any, by Salah?
There's no evidence anywhere about what Dr. Salah saw or didn't see. He was retained very early in the case, and there's really no information about what he did, what he saw, what he didn't see.
There's no transmittal letters or anything?
Nothing of any kind in the record. So I can't, we don't really know anything about, but he couldn't have seen records that defense counsel never sought and obtained. And that's what we're talking about here. And so to me, the issue is really, to me, it's a clear case of negligence. And the issue really is the issue of prejudice. To me, that's really where the rubber should meet the road in this case. Because I think any lawyer has an obligation where he was told by Noguera, get my Social Security disability records. They're really important. He never did that. So to me, the issue is prejudice. And on the issue of prejudice, to me, where that the trial judge said that counsel made a reasonable strategic decision not to use these records. And I don't see how you can make a reasonable strategic decision whether to use or not use something that you don't have, that you've never looked at. It's not a strategic decision. It just isn't. And so I think that finding is clearly erroneous. Whether or not he decides to use them is obviously, that is a strategic decision. But you have to be able to see them to make the choice.
Is that coupled with the decision to put his client on the stand to talk about his mental illness, and then without the cooperation?
I think that's a really good point, Your Honor. It is, because you're putting him up there, basically, you're hanging him out to dry.
If one of your clients had another defense, I didn't do it, right, and they'd ride that horse, that's a different story about prejudice.
Well, and here he puts on, what I would frankly submit was a rather lame self-defense claim where the decedent was shot in the back of the head. And he argued, his mental health was an important issue at trial. It wasn't just his testimony. Veronica Suarez, his longtime girlfriend, testified about his hallucinations, his symptoms. Ed Jacobs, an important witness, testified that he was acting erratically, that he'd lost it after Smith kicked him out of their hotel room. The defense counsel argued mental illness in his closing argument. The judge instructed the jury that they could consider credible evidence of mental illness. So this was not some throw-in. This was an important, and the prosecutor argued in closing that he's fabricating this. This is self-serving. There's no documents to back it up. So if you shouldn't believe this, and by inference, you shouldn't believe anything he says.
At one point, you were saying that you're not relying as much on the cross. You're relying on two different things, and the first one you've addressed. And the second one, I'm not sure if you're going to address 33E or the closing as it relates
It is
to Susan.
33, Your Honor, because I think, to me, these two things go together. This was a man with a serious, long-standing mental illness. He was a victim of abuse, and he killed. And to me, the combination of his lawyer not presenting the records that would corroborate his mental illness, to give the jury a fair chance to assess it, combined with just the fact that the combination of mental illness and abuse is kind of a combination, and I know every case is different, but this court in the past, in cases like Colleran and Berry and other cases, have looked at that and said, well, look, maybe there should be some mitigation here.
Well, let's see where it goes to, though, because it's not a criminal responsibility case, so is it, does it go to diminished capacity? Does it go to the lack of capacity to formulate the requisite intent?
I think that's right. I think it's diminished capacity. I think that it's acting that is acting impulsively based on his messed up, mentally ill mind, combined with a feeling of paranoia and fear based on all of these threats that are laid out in the text messages that are quoted in the brief. He's going to hurt him. He's going to hurt his family. He's going to hurt his son. He knows where they live. All of that stuff combined to operate on this man's distorted, diseased mind to result in this tragedy.
So the layers you're asking us to reach are, it's ineffective assistance of counsel, there's clear negligence, there's prejudice, new trial. If we don't go there, 33E mitigation.
I think that's right, Your Honor. But I think Your Honor really kind of put a gloss on it that I didn't do as effectively as Your Honor did, which is he really did hang Noguera out to dry by putting him on the stand to testify about his mental illness without anything to back it up, even though these records were available. I got these records. I mean, it wasn't that difficult to get them without ever bothering to read the Suffolk County records. It is like Alvarez. Just like in Alvarez, the records didn't correlate perfectly with the defendant's testimony. I agree with the Commonwealth when they point that out. In Alvarez, the defendant had told the defense expert that she was in a coma for months and had a steel plate in her head as a result of an accident. The records there was nothing in the records about a steel plate. In fact, she was in a coma for maybe several weeks, not months. But this court said those details don't matter. The record still would have corroborated the overall picture that this was somebody who had severe repercussions as a result of that accident. Similarly here, even though they don't correlate perfectly with his testimony, the records would have corroborated this was a man with a long-standing history of mental illness and treatment, and they would have at least seriously blunted the prosecution's extremely effective attack on his credibility based on the absence of any records at all.
How does his cocaine use or drug use come into play?
I'm not sure, Your Honor. I mean, there was no testimony about drug use around the time of the killing. Like many mentally ill people self-medicate with drugs. That's not an excuse, but that's what happens. I don't really think it particularly enters into it. This was not an intoxication defense. There was no evidence he had been drinking or using drugs within 24 hours of the killing. So while that certainly is part of who he was, I don't believe that's directly relevant to the arguments that I'm making in this appeal. If there are no further questions, I thank the court for its time.
Thank you. Okay, Attorney Lee.
Good morning. May it please the court, Mary Lee, Assistant District Attorney from the Bristol District for the Commonwealth. Because this is 33, I'm happy to attempt to answer any questions that you have on any topic, but if you don't have immediate questions, I'd like to go back to a couple of questions my brother
I have an
referenced.
immediate question, picked up on Mr. Sultan's point, which is how can something be strategic if it hasn't been reviewed?
Right, so from that, the answer is no. If you haven't reviewed anything, it can't be strategic. And the Commonwealth's position is the defense counsel here did review things, and he did talk to 2 experts, and therefore did make a strategic decision. But you're correct. If he didn't review anything and these records were helpful to the defendant, then that can't be a strategic decision. But here, we don't have that.
I don't want to step on Justice Lowy's question, but could you go through the 4 categories of records? I'm sorry, the first set of records, I can't read my own hand.
Records.
Fort
Dix.
Dix,
I'm sorry, military, that's what
Yes.
that word says, I'm sorry. The military records, the SSI records, the Hackensack records, and the Joe records. What, in your view, the evidence shows about review of those?
Yes, so the Fort Dix records are the only records that date back 30 years. The defendant claimed not just that he had a mental illness, but that he had a 30-year diagnosis of schizoaffective disorder and a 30-year diagnosis of bipolar disorder. And he testified about that in his direct examination. And the defense on appeal claims the Fort Dix records would show that, that he was discharged because there was a suicide attempt. But those records don't show that he had schizoaffective disorder. They don't show that he had bipolar disorder. They actually have a different diagnosis of borderline personality disorder. And so those contradict his claim.
Sorry, I'm sorry, no dispute, he didn't get the military records.
He did not get those records.
That's-
He attempted to. His notes show that he made attempts to get those records. There was communication with the military, but he did not achieve those records. He did not review those records. And so the Commonwealth's claim here is that they don't help the defense at all because they contradict the defendant's claim. They do show that he had mental illness back then.
going, because it's really important to go through these 4 different categories.
Right, yes.
To understand.
Each one stands on its own, yes.
Yeah, and then we look at the whole thing.
Yes.
So going back to Fort Dix and the Army, and Mr. Sultan's point about Alvarez, well, yeah, it's not a perfect fit, but at least he gets to go to the witness stand with records that says this is long-standing.
Right, so one, it cannot go to his mental health at the time of the crime because they predate the crime by 30 years, and that's Commonwealth versus Spray. But also, these records, as I said, here you can see the prosecutor going right to the point. Those were the first questions that she asked on cross-examination. If these records were presented to the jury, the prosecutor would be going at them saying, where's the schizoaffective disorder? Where's the bipolar disorder? Where's the mental health treatment? He was in the Army, he had a suicide attempt, they reviewed him, made a medical diagnosis, and he went on his way. This does not show a 30-year history of treatment records, which is what her point was in her cross-examination. Where is this history of treatment records? So this doesn't disprove the prosecutor's point, and it contradicts the defendant's testimony. Now, if we look at what the trial strategy of counsel was, and this is in his testimony at the motion for new trial, he was concerned, after speaking to the 2 experts and reviewing some records, that the defendant was embellishing his mental illness, that he was overstating it for the purposes of his defense. And I would suggest the Fort Dix records are exactly the problem that defense counsel was worried about. The defense counsel didn't want it to look like he was embellishing his claims in order to get rid of this murder charge. And Fort Dix goes to that because he didn't have a 30-year history of schizoaffective disorder. He didn't have a 30-year history of bipolar disorder. And so defense counsel was steering clear of that. The absence of those records is consistent with the strategy. I'm sorry, Your Honor.
Yeah, it's tough to be strategic when he doesn't know. But let's go to the next category, the SSI records.
So I agree the defendant specifically asked his attorney to get the Social Security Administration records. It's in his letter to counsel. And he said, that is where you will see the most comprehensive list of my treatment records. And counsel went to get every set of treatment records that were in that list. So he never got the SSI, never attempted to get the Social Security Administration records. And so he should have done that. His client asked him to do it, he should have done that. So our argument on this one is prejudice. There's no prejudice here because counsel did get the two sets of treatment records that are within the Social Security Administration records, Dr. Danishmand and Lahai, which are medical records. And he asked for 2013 to 14 for Dr. Danishmand. The Social Security Administration records had 2011 to 2014. Both sets of those records from Social Security Administration show a diagnosis of bipolar disorder beginning in 2011. So it's not a 30-year history. It does corroborate bipolar disorder, but nothing about schizoaffective disorder. So I would suggest one, and this is one of the points that I had originally wanted to make when my brother was arguing. Justice Lowy, I believe, said that SSA was part of Hackensack. I think what you meant to say is that the Social Security Administration included the Danishmand records, not the Hackensack records. So the psychological treatment records that are within the Social Security Administration records, in fact, trial counsel had those. They're the Dr. Danishmand records. We have the letters to Dr. Danishmand. The defendant is not claiming he didn't get those, and those would be records that were sent to Dr. Brown and were later destroyed, and they would show a bipolar diagnosis, but not dating back 30 years. I would also just like to point out, this goes to a question that was earlier asked by Justice Gaziano, which was, how do we know what Dr. Zale and what Dr. Brown saw? The Commonwealth, in its original response to the motion for new trial, specifically asked for discovery about Dr. Brown and Dr. Zale. We wanted to call them as witnesses at the motion for new trial. That was preliminarily denied after the Commonwealth's request by the trial judge. We presented the evidentiary hearing, and those witnesses were not called. And at the end of the hearing, I renewed my request to call Dr. Zale and Dr. Brown, so we could know exactly the answer to the question that Justice Gaziano has just asked. What records did you get? What advice did you get? Did you give? What was the big danger in these records that you gave this advice to counsel, and then he acted on it and made this strategy? And we could even ask Dr. Brown, do you have any recollection of what records you received? Did you get Hackensack? Did you get Dr. Danishmand? Did you get any of the other records? Did you look at Suffolk? But we don't know the answer to that question because defense objected to the Commonwealth getting to that point, and the judge didn't permit the Commonwealth to call those witnesses. And so if the hole in the evidence is there, that is the defendant's burden to show. If this court isn't satisfied, then that remedy would be a remand for a hearing so we could call those witnesses and get right to that point. My point is the defendant, by blocking us from getting that evidence, by not calling those witnesses, has not answered the question of exactly what information trial counsel had and what information was given to him by Dr. Zale and Dr. Brown. And the Commonwealth was blocked by that ruling, and we objected at the hearing. So I would suggest that's not a reason to allow the defendant's motion that there is a hole in that evidence.
Relates to the defendant's burden on the motion for new trial.
Yes. He has to show justice has not been done. That's a heavy burden after a conviction by a jury. Additionally, the big problem with the Social Security records.
Can you remind me, counsel, what was the basis of the denial of the Commonwealth's request? Privilege?
My brother stated that that wasn't the point of his motion and that it was part of the defense privilege to, and they have a privilege to keep stuff away from us, but they can't then use it to say, too bad you don't know this information. Like that's, it's their burden. If you waive your privilege in order to meet your burden when you're claiming ineffective assistance of counsel, and I was blocked after 2 requests and an objection.
The Hackensack records?
Could I make one more point about the Social Security records?
Certainly.
The Social Security records then actually make the Commonwealth's point. In 2014, the defendant asked for benefits. He claimed he had schizoaffective disorder. He has never, in the Social Security records, have a finding of schizoaffective disorder all the way up to 2014. But in 2014, the Social Security Administration said you're losing your benefits because you haven't provided record information that supports your claim of any mental illness, including bipolar disorder, and his benefits were cut off in January of 2000. His last benefits were January 2015. The murder is November 2016. So that exactly shows the prosecutor's point. You're claiming you have all these mental illnesses. Give us the proof of it. He didn't. That was the
I
prosecutor's
don't know what to do with
cross-examination.
this comment, but sometimes people with mental illnesses don't have the ability to get what they need to get to affirm their mental illness because they have mental illness.
And if you wanted to present that, you would have to call an expert on that. That's not a matter of common knowledge. I agree with you. My experience as a prosecutor, I've seen that people don't go and get the help they need and they are blockaded from getting the help they need. We don't have that evidence about this defendant from an expert in this case, and that's not something that we can just presume from the record in this case, particularly where the experts were not called. The Hackensack records, the Commonwealth maintains that the defense attorney requested the Hackensack records, the letters are in the record appendix, and that his notes mark that they were received. Because we couldn't call Dr. Brown, we couldn't substantiate that Dr. Brown actually saw them, but we have a finding from the judge that the Hackensack records were received. That's a 2010 hospitalization. Now, the defendant had testified he had a 30-year history of hospitalizations. This is the only record that shows a hospitalization. He did say the last time he had a hospitalization was in that time period, so it would have corroborated him on that. But what's the problem with the Hackensack records? It's exactly what we've been talking about. There's no reference to schizoaffective disorder, only bipolar disorder and borderline personality disorder. Those records show the exact problem that the defendant is exaggerating his symptoms, and he's doing it for the purposes of this case. And trial counsel would have been perfectly within his, under Commonwealth versus Dawn, trial counsel's strategic decisions are given deference. Under Commonwealth versus Tevlin, we consider the defendant's trial strategy. So the record as it stands, he requested the Hackensack records, he got the Hackensack records, he showed them to an expert, he talked to the expert more than once, and he made a decision to stay away from it because he didn't feel it would help.
That was a psychiatric hospitalization, correct?
Yes.
All right, so when
There's-
this cross-examination of you have no records of psychiatric hospitalization, and the defense attorney says, aha, I do. It's
I could have gone and got Hackensack,
It's
but he
Hackensack.
didn't.
But he doesn't raise that as an issue. He doesn't raise that in rebuttal, correct?
He does not. And he didn't ask for continuance to go get them. He didn't ask for continuance to call Dr. Brown or to see if Dr. Brown still had the records. It would appear the records probably existed at that time period from Dr. Brown's email, which is part of this record. It looks like he was moving his office during COVID lockdown. This was one of the last trials in our county before lockdown. It was in February 2020. Those records may have even existed at Dr. Brown's office at the time. But trial counsel's strategy was to stay away from that. He felt that it hurt the defendant's case after.
That's sort of the question. So the cross is over. Now it's redirect. If the Hackensack records are at your fingertips, then you make a craft of advocacy determination of whether to redirect. Oh, no, actually, there you go.
Right,
Or you don't know you haven't looked at them, and it's not strategic because you can't make a craft decision about what you haven't seen. So which one is it?
So he received them, and he said that he's not a doctor. He relies on experts. So he sent them what records he received to Dr. Brown and then talked to Dr. Brown about it, and I think that's perfectly reasonable. My reading of Hackensack is not an expert reading of Hackensack, and as well as this court's, regardless of how experienced you are, you're not psychiatric experts in this case to look at those records. And so I think it was smart of him to send them to an expert, and he made a decision and stuck with it.
But what may not be smart is if you're being cross-examined and grilled and saying, if you were hospitalized in a mental institution, we'd know it, we'd have records. And then you sit on your hands and say, oh, well, I guess Hackensack, but maybe not, so I say nothing.
So he said he anticipated the question from the prosecutor. He thought that the defendant testified well. There's no objection on the record at that point. Then the prosecutor makes a statement. She did not say, my brother said, she said he was fabricating. She did not say fabricating. She said, and I think I quoted it, but she said, now, first of all, with respect to his mental condition, all we have, ladies and gentlemen, are the defendant's self-serving statements that for 30 years he suffered from schizoaffective disorder and from bipolar disorder, same from his girlfriend, Veronica Suarez. Yet he was unable to produce one single record to support the proposition that he was, in fact, suffering from any type of mental illness. That's at transcript 1757 to 58. So she didn't use the word lie or fabricate. But She points out that one sentence. That's all she says about it. And what does counsel do? Because that was evidence, she's allowed to comment on it. He objects. He gets that essentially stricken. The trial judge then says, defendant's under no burden. He doesn't have to produce any records. So her point is then undermined. And counsel said that he felt, in the motion for new trial hearing, he said he felt that that was sufficient to remedy the defendant's rights, and then he didn't have to open the door to these records and this expert evidence that he thought was so harmful after investigation to the defendant.
That was in the closing argument.
That's the closing argument.
Right, but the question had been asked in cross, though, right?
There's 3 questions on cross. That's at transcript 15-208 to 209. And do you have any of these records supporting a claim that you have been hospitalized multiple times over a 30-year period? Hackensack wouldn't address that.
And that's, Justice Loy was intimating that could have been redirect if
It could have been
if he had them in his trial bag and he just didn't.
It could have been if that was his strategy. The other one,
Question, what comes first? Because it's fine not to redirect on that as a strategic decision. What's not fine is not to have the option because you didn't investigate.
right. I don't think that applies to Hackensack respectfully, because the record shows he got Hackensack, looked at them, sent them to Dr. Brown, talked about all the records he sent to Dr. Brown with Dr. Brown, and then anticipated this question and then used this strategy to undercut the prosecutor's closing argument.
And before you conclude, not to rush you off in your 2 minutes, but the Suffolk County records.
Right, so the Suffolk County records are post-crime, so they are difficult for the defendant because he's already got his motive to create a record. His diagnosis was based on his statements to the counselor, and those records were half of those records, up to April 2018, were summoned into the court records for the purposes of Dr. Brown to be able to review. It was the Judge McGuire, who summons them in. And the docket shows that those were psychiatric records that came in. And in that time period, it has schizoaffective disorder, it has the medications he was prescribed, and Dr. Brown, I understand my brother is saying, well, we don't know that Dr. Brown reviewed them or didn't. Aside from the fact that I couldn't call Dr. Brown to determine that, Dr. Brown's preliminary report, which is part of the record, does note schizoaffective disorder and does note his prescriptions. So I would suggest that preliminary report would indicate that he was familiar with these records that had been summoned in for the purposes of him to look at them.
What was the purported strategic reason for keeping these out? Can you just articulate that for me?
Strategic reason for keeping out the Suffolk
why
records?
would you not bring in the Hackensack record or the military or the Social Security? What would be the...
Counsel felt that the records would support the defendant embellishing his statements and about his mental illness, and that it would hurt his credibility.
Because they said bipolar and not schizoaffective,
He didn't.
or because it was X number of years as opposed to 30?
He didn't give the reasons. He said there were things he didn't want the Commonwealth to see. I tried to be very careful of the defendant's privilege regarding that thought process when I was questioning him, but he said there's stuff in there he didn't want the Commonwealth to see. He thought it would hurt his client. And so we know that counsel saw Dr. Brown's preliminary report, which does, and I didn't look at that right before argument, but I'm very confident that it showed that there was a diagnosis, a long-term diagnosis written in the preliminary report. There was a I don't know where Dr. Brown got that from. I can't prove that Dr. Brown read the Suffolk records.
PTSD, anxiety, paranoia, disassociation.
Oh, it doesn't have schizoaffective in it?
No, I think it's depression and hallucinations. Oh, and bipolar.
Bipolar. So, well, and then that would cut.
Oh, I'm sorry, and schizoaffective. Yeah.
Schizoaffective disorder.
Get
Okay.
everything in there.
I was worried about my memory there. I'm sorry, I'm running out of time. My point is, we know counsel had Dr. Brown's preliminary report, so we know he knew about those diagnoses, and those records were brought in specifically for Dr. Brown. I can't tell you that Dr. Brown looked at them because we didn't get to call Dr. Brown. My time is up. I apologize for going over. I would ask this court to affirm the defendant's conviction except for the firearm charge because of Guardado.